हाँ भाई, तो लास्ट क्लास में अपन ने आर्टिकल 26 तक देख लिया था। 27 देखना बाकी था। I have also discussed that article 25, 26, 27, 28, basically all these article talks about right to religion, and article 26 talk about right to religion for individual perspective. Article 26 talks about right to religion for community basis. Article 27 talks about no person or no any authority to pay any type of taxes for the money which has been used for the upgradation, for the upliftment, for the propagation of any religious community. Therefore, and we have already discussed 25, 26. We have also discussed in the Sirur Mat case, Supreme Court gives its judgment where he laid down the criteria of essential religious practice, basically ERP, which cannot be affected by the state legislature or the parliament by law. And who will decide the essential religious practice? Basically, Supreme Court will decide the essential religious practice. But there is a criticism which has been made on this judgment because Supreme Court is not basically on the basis of who can judge the belief of any person, how the religious practice, how the what is the core practice of any religion. Basically, it depends on the belief of any person, belief of any community, belief of any society. So Supreme Court cannot decide solely on the basis of that. So basically, that is the judgment in this Rurmat case. Now let us discuss about the Article 27 of the Constitution of India. Let's read from the Bayer Act of the Constitution of India, which we have already mentioned earlier. Now, let's read. Freedom as to payment of taxes for promotion of any particular religion. Basically, no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion for maintenance of any particular religion or religious denomination. So basically, Article 27 talks about no person compelled to pay any tax for promotion of for money which used promotion of any religious denomination. So basically that's the article 27 says no person have to pay any type of taxes on money which has been used for the purpose of propagation of or promotion of spread of any religious denomination. So that is the basically article 27 talks about. Now we have done with article 27. Now let's read article 28 of the Constitution of India. What the article 28 says. Article 28 have three clauses. Basically, first we read the first clause, freedom as to attendance at religious instructions or religious worship in certain educational institution. So basically, it's talk about right to freedom for instruction in any religious institution or in any educational institution to follow any religious institution. So basically, Article 28 talks about restrictions as well as freedom about religious worship in certain institution. Now let's read Article 28 Clause 1 of the Constitution. What the Article 28 Clause 1 says? No religious instruction shall be provided in any educational institution wholly maintained out of state funds. So basically states that institution maintained by Any institution, basically any institution maintained by state fund, there no any religious instruction can be followed. So that is the basically Article 28 Clause 1 says. Article 28 Clause 1 says that no religious or worship in any institution which has been funded by state fund or by public fund. So basically, no religious activity in institution which funded by government. But exception to this Article 28 Clause 1 is in Article 28 Clause 2. So basically, Article 28 Clause 2 is exceptions to Article 28 Clause 1. What is exception? Read first, then we will discuss. Nothing in clause 1 shall apply to the education institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. So basically, under Article 28 Clause 1, it is exceptions to article, under Article 28 Clause 1. Basically, it is state despite funded by state, no restriction of 28 clause 1 will apply if educational institutions set up for providing religious institution. So basically, if any institution is basically made for religious perspective, then whether it will be funded by a government, whether it will not be funded by government, state restriction mentioned in Article 21, Article 28, Clause 1 will not apply on it. So basically, religious activity can happen on those institutions which are solely maintained, sorry, which are solely made for the purpose of religious instructions. Now it should be clear. So Article 28 Clause 1 says no religious activity in any institution which are funded by government. Basically, you can say state government, colleges, central government colleges, or 12th government college. So basically, all the government college which are funded by the state, there no any type of religious activity can be provided. But exception has been given to Article 28 Clause 2 where it states that institutions which are made for the purpose of religion, here Article 28 Clause 1 will not apply. So this is the Article 28 Clause 2. Now let us also read Article 28 Clause 3 of the Constitution of India. Article 28 Clause 3 states that no person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instructions that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto unless such person or if such person is a minor his guardian has given his consent thereto. So basically, Article 28, Clause 3 states that educational institution recognized by recognized by the state or funded by state or funded by state, in these institutions no compulsory religious education or worship can be imparted, that is fully choice of children. So basically, Article 28, Clause 3 says that if any educational institution which has been funded by government or any help given by the state, in those institutions no religious activities should be imposed on any children, or no compulsory religious education will be given to any children. If it is given, then it should be taken prior consent of the children. If children is minor, then prior consent of parents of children. Now it should be clear. We have discussed all the cases of Article 28 Clause 3. But there is one another case which has been goes to the Supreme Court in the case of Aruna Roy versus Union of India. So in case of Aruna Roy versus Union of India, Supreme Court stated that prohibition of study of religion is unconstitutional because religious study would lead to deep value strength between religions. So in the case of Aruna Roy versus Union of India, Supreme Court stated prohibition of study of religion. Basically, you cannot impose compulsory regulation. If any student, if there is any course, मान लो आप सेंट्रल यूनिवर्सिटी में गए, वहां पर एक बुद्धिज्म का कोर्स चल रहा था, वहां पर हिंदुइज्म का कोर्स चल रहा था, वहां पर जैनिज्म का कोर्स चल रहा था, वहां पर मुस्लिम कम्युनिटी का कोर्स चल रहा था, तो इट इज ओके. But if you are imposing compulsory regulation that you have to participate in this religion, you have to participate in this course, you have to participate in this course, you have to participate in this course, then that is not okay. But if any student wants to read such religious uh, book or any Ved, if it is the Hinduism, then it is okay because it will lead to deep understanding and faith between the religions. So this is all about right to religion, which has been mentioned under Article 25 to 28. So Article 25 we have discussed right to religion with individual level. Article 26 right to religion with community level. Article 27 no taxation for money which has been given to the propagation or promotion of religious institution. Article 28 we have discussed right now. Basically, it states that if any educational institution is completely maintained by a state fund, then no religious activity will be happen. Exception has been provided under Article 20 Clause 28 Clause 2, where if educational institution is maintained for religious purpose, then there can be possibility that religious instructions can be followed. And Article 28 Clause 3 states that no compulsory religious education should be imposed on any children or any student. And Supreme Court in the case of Aruna Rai versus Union of India stated that Supreme Court stated that prohibition and study of religion prohibition on study of religion is unconstitutional because it will lead to because if you are understanding deep study then it will further led to the brotherhood or the fraternity between the peoples of between the different community. So it is good for, so you have to you cannot restrict the study of religion in the university, you should allow. So it will okay. Now let us read about the article 29 and 30. So we have discussed article 25, 26, 27, 28. We have discussed all of these. We have also discussed essential religious practice, which has been laid down by this Rurmat case. We have also discussed Article 25 of the Constitution of India, right to religions to individual. All person have right to follow any religions, to practice any religions, to freedom to prayer, to all. And these are not also absolute grounds. Basically, they are uh, restricted on the ground of public order, health, and morality. Article 25, Clause 2, Subclause A is exceptions to basically states. State can make law for the economic, political, and financial activity of religious institution. And Article 25, Clause 2, Clause B says that state can make law for the social welfare on any religious institution. Basically, they can also regulate they can also regulate the internal matter of the religion. And Article 26 talks about right to religion for the community level. Basically, it states that every religion denomination shall have right to establish their religion, to establish their institution, and they have also right to maintain and regulate these institutions, and they have also right to acquire immovable or movable property. Then they have also right to maintain their property. Now article 27 talks about no person is compelled to pay any type of taxes on money which has been funded to for the religious propagation or promotion. And article 28 clause says that restrictions as well as freedom about the religious institutions. This Article 28 clause 1 says that any institution maintained by state fund, there in those institutions no any specific religion can be followed, and basically no religious activity in such institution. Article 28 clause 2 says that exceptions basically despite funded by state government, if state is solely made for the reason of religious activity, then Article 28 clause 1 uh, ground will not apply on it. And Article 28 clause 3 states that education institution recognized by state or funded by state, if no compulsory religion education can be imparted, but if any student choice want to study, then they can study if any course is happen. And also in the Aruna Rai versus Union of India case, Supreme Court also stated that prohibition of study of religion is unconstitutional because religion religious study would lead to lead to increase deep value strength between religions. So that is the basically Article 28, which talks about right to religion. Now let's move towards right to exploitation, which we have already discussed, I think. Okay, now let us read about Article 29 and Article 30 of the Constitution of India, which talks about cultural and educational right. First, read about Article 29 of the Constitution of India, then we will move on Article 30 of the Constitution of India. So now first read protection of interest of minorities. Let's read 1 minute. Now, let's discuss about cultural and educational right. Now, we have already discussed right to religion. Now, let's move on to Article 28. So, let's read first Article 29 of the Constitution of India. Any section protection of interest of minorities. So, basically, it talks about the minorities' interest. So, basically, Article 29 talks about protection of minorities. How? Let's read first Article 29, Clause 1. Any section of the citizen residing in the territory of India or any part thereof having a distinct language, script, or culture have its own shall have the right to conserve the same. So basically it states that any section, basically it may be on the basis of language, it may be on the basis of religion, it may be on the basis of any other perspective. So any section basically for the minorities. So it need not be compulsory that any this section will be based on the religion. No, it may be a possibility that within the Hinduism there are many sections who speak different language. Within the Muslim community, it may be a possibility that there should be a various section. Within the Buddhism, within the Jainism, within the Sikhism, it may be a possibility that there should be various sections which should be divided on the basis of language, on the basis of their ethnicity, on the basis of their culture. So in every aspect, so basically here they have not clearly mentioned on the perspective of religion, so that they have mentioned the word section. So any section of citizen of India have a right to conserve their language and protect their minority status. Basically, minority protect their cultural diversity and protect their minority status. That is basically, if you are in majority, then it is okay. But if any section which may be based on language, which may be based on ethnicity, which may be based on religion, which may be based on any type of section, have the right to conserve their language, to conserve their culture, to conserve their ethnicity. So basically, on the ground which they have got the minority status. Basically, it may be on the language. So on the ground which they have got the minority status, they can conserve their ground of minority status. So they can do whatever they want on that ground. So that is the basically Article 28 Clause 1 says about. Now let us read Article 28 Clause 2. So basically, they can set up their own religious institution, they can set up their own linguistic institution, they have right to establish their institution, their uh, propagation for the conservation of their language, culture, society, and ethnicity. Now, let us read Article 28, Clause 2. No citizen shall be denied admission into any educational institution maintained by a state or receiving aid out of state fund or grounds only of religion, race, caste, sex, no, no, religion, race, caste, language, or any of them. So basically, it states that Article 28, Clause 2 says that no discrimination with respect to admission in educational institution which funded by government on the ground of race, caste, language, etc. But clearly the ground sex has not been mentioned, so state can discriminate. For the example, we have seen that there have been established separate institution for the girls. So state can discriminate on the basis of your sex. So basically, state can make institution, state can make separate provisions for the promotion of, for the upliftment of the girls. So एग्जाम्पल के तौर पर अगर अपन बात करें, एग्जाम्पल girls institution, so missing, so basically you can say sex ground is missing. So example के girls institution based on ground this. I think now it should be okay. Now we have done with Article 29 of the Constitution of India. Basically, Article 29 Clause 1 says that any section of citizen, any section, basically section means language, linguistic criteria, and whatever way they are in minority, they have the right to conserve their cultural and language and their uh, ethnicity. And under Article 22, so under Article 20 in 29 clause 1, it's inherently include that they have right to establish their own educational institution, basically purely based on their propagation of religion, language, or etc. Now, Article 28 clause 2 says that no discrimination with respect to admission in educational institutions which are totally funded by the state government or partially funded by the state government or union government on the ground of caste, race, language. Now, let's move towards Article 30 of the Constitution of India. What the Article 30 says? Article 30 says that right of minorities to establish and administer educational institutions. So, Article 30 gives right to establish their and maintain their institution. Now let us read Article 30 Clause 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. So basically, हाँ, it may be a possibility you will not follow any religion. अच्छा हो सकता है कि भाई आप कोई रिलीजन को फॉलो ही नहीं करते हैं. एक ऐसी सोसाइटी भी तो हो सकती है जो किसी भी रिलीजन को फॉलो ही ना करती हो, सेकुलर हो. तो ये राइट उनके पास भी तो होना चाहिए ना कि भाई सेकुलर हो तुम, हाँ है, आपके पास भी राइट है कि आप अपनी सेकुलर इंस्टीट्यूशन बना दो जहां पर किसी भी प्रकार की कोई भी रिलीजियस एक्टिविटी नहीं होगी, वहां पर केवल और केवल मॉडर्न एजुकेशनल ही पढ़ाई जाएगी. मे बी अ पॉसिबिलिटी दैट यू आर इन माइनॉरिटी with respect to secularism. So you have the right to maintain, to make any institution which is totally for the modern education. Now it should be okay.